JVs have continued to be one of the most attractive choices for entry into a market, for expansion, to diversify, to share costs and risks in a particular sector. And that is the case with India as well. There are various sectors in which JVs have historically happened and are continuing. In terms of identifying and choosing potential JV partners, background checks and a thorough legal due diligence has gained a lot of importance. While it's quite obvious that you will have to identify the strengths and the weaknesses of each of the two partners, make sure that you harmonize them properly and who will do what going forward. In the context of reserve matters, care should be taken that while it gives adequate protection to either of the parties, one of the most important things to do is to have certain thresholds, whether monetary or otherwise, within the list so that they do not interfere with the day-to-day functioning of the company. In the context of related party transactions, as long as it's on an arm's length basis and it's disclosed upfront, the partners will get a lot of comfort out of that. One of the key concerns is that the local partner might use the knowledge gained from the joint venture for rival sort of businesses. So it is very, very common and in fact recommended that strict non-compete and non-solicitation clauses are set in the document. One of the things that is quite critical in a joint venture is the decision with respect to which of the two joint venture partners will have the right to appoint the key managerial personnel. In the event that the parties discuss that perhaps one of the joint venture partners will be appointing the KMP or the CFO, then there has to be a clear sort of understanding with respect to how the information will flow regularly to each of the partners. Of course, the minor day-to-day sort of issues, those can be best tackled by having a robust business plan or having an escalation mechanism within the contract. The worry really is on the bigger disagreements which lead to a deadlock situation where it is possible that the joint venture itself could crumble. So it is important that at least the business continues as is till the resolution of the dispute happens. But at the same time, a proper exit mechanism is definitely required. Also, how the exit is really going to impact contractual obligations of the company have to be really looked at. So for example, what sort of a brand licensing you have, what sort of technology licensing you have, and how that is going to be treated if the exit was to happen. So joint ventures continue to be the classic choice for strategic investors. There have been various positive developments in the country lately, such as changes to the Specific Relief Act, certain decisions of the courts where contractual obligations have been enforced. And all of these things put together have been very assuring in terms of investor confidence. And I think that's a great sign.